All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Evander, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to the session of the 5th District Court of Appeal. As the Marshal mentioned, Judge Evander, I'll be presiding. Seated to my right is Judge Lawson, and to my left, Judge Cohen. We have 3 oral arguments scheduled for this morning. 2 are criminal cases. Each side will have 15 minutes to argue. The appellant can go ahead and advise me of how much time they wish to have set aside for rebuttal. I'll try to help in that regard. We have 1 civil case, 20 minutes aside. If you have any cell phones, please make sure you turn them off now so that the attorneys are not interrupted during their argument. Having said that, we will, after the second argument, we'll be taking a short break and invite any of the attorneys to join us in the attorney's lounge for coffee. Take up first the case of Smith versus State.
May it please the court, I'm John Notarian. I represent Michael Smith in this matter. Good morning, Your Honors. I'd like to reserve 3 minutes of my time for rebuttal.
Okay, you may proceed.
Thank you. Your Honors, this is a case that's already been up here once before. It went back to straighten out the plea consequence and colloquy to indicate that the defendant and the other parties had agreed to.
Let me ask you this. In the answer brief, the state discusses the Reeves case from the 1st District Court of Appeal, and you don't address that in your reply brief. I think my view is that if we agree with the 1st District in that case, that would...
Well, with regard to the C4 motion, Your Honor, or with regard to the... that's the victim as a passenger in the other car of the drag race.
They rely on a prior case from the 1st saying that the decedent's conduct can only be asserted as a defense to vehicular homicide when that conduct could be viewed as the sole proximate cause of the accident which resulted in the death.
Right.
So it distinguishes the case you rely on, Velasquez, and
Well, I think the sole distinguishment here, Your Honor,
What's
is
that?
the sole distinguishment in all of these cases, there's clearly a dichotomy that the McKell case out of this court addresses, that we have co-participant cases, and I understand in the Reeves case, the passenger of the other drag racing car was the victim. What they distinguish, though, in the Reeves case, if memory serves me correctly, is that nothing is shown in that case to show that that passenger did anything like in the JAC case, grab the wheel, or that she even consented to the drag race. So that is the distinction.
she was a passenger in the car.
I understand.
I guess could have gotten out, I don't know, but...
I guess once the race began, I'm not completely familiar with the way the case was presented to that court, but they draw the distinguishment between victims who are co-participants, third parties, or who did not participate in the event.
But you would agree that the victim in this case could not be viewed as the sole proximate cause of his death? I mean, he didn't propel the shopping cart up to 25 or so miles an hour. He didn't choose the direction of travel. He didn't, I mean,
Well,
your client did that in his driving.
Well, I would agree with that, Judge. What the evidence, what the C4 alleged and what the Traverse did not allege, that in nowhere in the Traverse does it say that the decedent did not consent to that. Not that there is a safe speed to propel a shopping cart with an SUV. I don't imagine that there is one. But nowhere in the Traverse does it say that this person did not consent to that.
So if I'm driving and someone is surfing on the top of the car and I hit a speed bump, the person flies off and dies, I consented to that. That's your argument, correct?
You consented to the foolish activity.
So there's no culpability for the driver?
That is kind of what the case law says, Judge. In McKell, it says that cases like Velasquez are plainly distinguishable from the facts of the McKell case where somebody rear-ended
I get into a car, I know the person has been drinking and is drunk. I've consented to that, correct?
distinguishable from these facts, Judge. There's nothing indicating that either person was intoxicated.
Well, it's consent. You know, your argument is that one can consent to this type of conduct, and
Sadly-
I just want to understand how far that goes.
Well, I guess we can use examples, Judge. We're right down the street is the Daytona 500, where rubbing is racing, people are going 200 miles per hour. If that isn't reckless driving, I don't know what is. And they intentionally collide with one another. And sadly, every now and then, people are killed in that event, and we would find it very strange to find one of those, or all of the participants on the track, to be charged with vehicular homicide.
So getting back to the question that I asked, if I know the driver's impaired and I get in the car, I have consented to that, correct?
That's an interesting point, Judge. I guess you have. That is not addressed by any of the case law, and I will,
But your argument would be that there would be no liability, no culpability for the driver in terms of the death of the passenger.
no, I can't say that, Judge. That's not the law. That's the DUI manslaughter law. And what we have here is a distinguishment between co-participant and third-party cases.
Okay, but back to Reeves. Reeves says that in the co-participant cases,
Yes.
it's a defense to criminal liability if the victim, the so-called victim, is the sole proximate cause of his or her death. But the fact that the victim willingly co-participated is not a defense where the victim is not the sole proximate cause of his or her death.
That is an interesting question, Judge, and the Velasquez case is what they all revert to, and I will tell you, there were some mental gymnastics in that case that I had to, quite frankly, write out because it didn't make a lot of sense to me. But what they say is that it's more than a but-for causation fact test modified by a substantial factor exception, that Florida and other courts have declined to impose criminal liability where the prohibited result of a defendant's conduct is beyond the scope of any fair assessment of the danger created. And I think that's what you're driving at, Judge Cohen. Or where it would be unjust based on policy considerations to hold a defendant criminally responsible. And I guess your question, Your Honor, is the fact that the vehicle proceeded at a high rate of speed. Does that vitiate the consent to the foolish participation in that behavior? I don't believe that in this case, anyone says that he didn't consent to traveling at that rate of speed. There's no allegation in the Traverse. So, you know, here we are, we have three people engage in a very foolish behavior, and tragically, one of them is killed.
So the way that would work is that when you get into the shopping cart, you say to the driver, now listen, you know, I consent to up to 10 miles an hour. Is that how it works?
Well, that's kind of the question, isn't it? I mean, there's nothing here where it says that anyone said that he didn't consent to traveling at that rate of speed. That's an allegation. The state's Traverse says that, and trial counsel in this case did agree that this is reckless driving. He informed the trial court, admittedly, this is reckless driving. You cannot call it anything but that, or in any set of circumstances.
But in terms of foreseeability and holding someone responsible for their own actions, I mean, if a person is foolish enough to agree to have someone hold onto their vehicle with a shopping cart and propel them forward, and they do that at 3 miles an hour in a straight line over no bumps, I mean, that's one thing. But if they accelerate to a significant speed and go over a speed bump, I mean, that's what caused the death. I mean, they were co-participants, but it was your client's action that foreseeable, if you're going to drive that fast and take somebody over a speed bump when they're holding on to your car in a shopping cart, I mean, I would think that, I don't see a public policy reason for not holding a person responsible under those circumstances, because they had to know that if they did that in a reckless manner, that it was going to cause harm to the person.
And I guess that's where the question is here. The Traverse does not allege that that person didn't consent to that. And I imagine the court saying, well, why would anyone consent to that? Well, why would anyone consent to getting out of a vehicle, getting a shopping cart, attaching it to the SUV, and telling the driver to drive forward?
I mean, so if you said, hey, let's play Russian roulette, and I take a gun and point it at you, and the bullet happens to be in that chamber, I'm not responsible because you agreed to that.
I believe there is a line of case law that goes along with that, and it's there's a manslaughter issue. I recall right now how that is resolved, but I would agree, Your Honor, it's foolhardy, it's ridiculous, but we have lots of examples of that in our society, particularly here in Central Florida. People engage in these behaviors all the time. I mean, the example I give in my brief is several years ago, tragically, one of our sheriffs from Lake County was killed when racing buses and shabby condition buses around a racetrack, and was tragically killed when struck by another sheriff from Seminole County, and we don't see prosecution there. I mean, where's the safety in that? Where's the safety in racing a race car at over 200 miles an hour and intentionally hitting another person? That's, I guess, where the case law goes here, and the McKell case out of this district gives us an idea of how we're to deal with these problems. And I understand the court's argument that when you exceed a certain speed limit, but that becomes a responsibility and consent issue. There's nothing here to say that these.
But doesn't it become a mitigation of sentence issue? The participation of the victim?
Well, it didn't appear to in this case. I didn't handle the sentencing in this matter, Judge.
But statutorily, it would be something to be considered a mitigation of sentence.
Yeah, sure, it would be one of the enumerated, that the victim was a co-participant. And, you know, I would agree with that. I certainly would. But this addresses the C4 that was filed by the trial counsel in this matter. And that's the way it proceeded. There are a lot of cases that talk about third-party people. Gensler case, I'm sure the state's going to make a big deal about, and that involved a police officer in South Florida that was traveling over 90 miles an hour, went through a yellow light and struck an intoxicated pedestrian. And the state denied, or the court denied the C4 motion there, but all of the cases discuss Velasquez and how the co-participant cases are markedly different than the third-party decedents who really don't participate other than being there. And even with their contributory negligence, these courts have indeed found that there is a marked reluctance to find co-participants responsible criminally for a victim's death when they're all co-participants in an agreed-upon foolhardy, criminally negligent episode.
You just got under 3 minutes.
Thank you, Judge.
Good morning, Your Honors. May it please the court, my name is Carmen Corrente, and I represent the state in this appeal. And to speak about the sole proximate cause that was just discussed, the state would like to point out something that really hasn't been fleshed out that well in the briefs, but we know from these facts whether or not the victim's action of hitching onto the side of the vehicle was the sole proximate cause. It wasn't, and that's because he traveled for 100 feet without injury. Just attaching himself to the side of that vehicle and riding along for a joyride in the shopping cart, as if you're towing someone on a skateboard, inline skates, however you want to do it, what his action was of just hitching on that car was not the cause of his death at all. It was the speed bump, and the speed which was attained during that 100 feet before he reached the speed bump. That's all done with the one motor vehicle, the one driver, the one person who could have controlled that. Mr. Bieberly, the victim, could not have even let go after a certain speed because he had no way to brake, he had no way to steer. He had no chance at a certain point to even take the chance, to take a risk of letting go. The sole proximate cause, really, of what happened here was the speed and direction of the motor vehicle driven by the only driver we had. And we can talk about the Velasquez case. I don't have to rely on Gensler, I don't have to rely on Reeves. I think those are both on point. They all discuss sole proximate cause. And Gensler was even better because that was a police officer defendant who had won a motion to dismiss below. And the court reversed it on appeal. Saw enough to reverse it and say, no, you've got to have a trial or a hearing on this. And the reason Velasquez supports the state's position here too is because, well, first of all, Velasquez is distinguishable. We've got a case that involved two cars, two motor vehicles, two drivers. And we also have an incident that occurred after their mutual event or consented action was over. Basically, one of the drivers was driving over 120 miles an hour on the way back to the start line after the race was over, and he was killed. Had nothing to do with the other driver. We have an independent motor vehicle and an independent act. But even if we want to look at, Velasquez has got a great, probably the best explanation of proximate cause. And we can look at it, and they say, first of all, the driver has to be a cause and fact of the death. And I think we've got that here clearly. I won't belabor that point. The but-for test is easily met, best phrased as the death would not have occurred in the absence of defendant's driving. I think there's no question about that because it didn't occur until the speed bump and until that speed was reached. So then you go down to the court say, well, if the victim and the defendant both engage in reckless acts, each of which would have caused the death, then you've got to look at whether or not the driver or the defendant was a substantial factor. Again, the only motor vehicle, the only driver. Yes, he was a substantial factor. And then we go into whether it was foreseeable. Well, they've stipulated below to the foreseeability because they stipulated it was reckless. So reckless being that it was recklessly driven, great bodily harm, or death could occur. So the last thing is public policy. And again, along with Judge Lawson, I don't think it's public policy that if you're as a driver of a vehicle and you have someone hitching a ride on the side of your car, on the top of your car, surfing, in the bed of the pickup, that you have a license therefore to drive at high speed over a known obstacle to either disengage them and have no criminal responsibility whatsoever. Defendant was arguably the proximate cause. That's what we're arguing. If that's an arguable issue, it's a jury question and would have been properly resolved by a jury. Therefore, the motion to dismiss was properly denied. If there are no questions, I'd ask this court
I
to
don't think
affirm.
there's anything in the record that, the defendant drove over the speed bump with the intention of disengaging the...
No, but there are cases, or I would imagine that there are cases out there where I learned in research for this case that the term is called skitching, and that is if you are using a skateboard, you're skating, or you're inline skating, and you hitch a ride on the back of a vehicle. It's a thing that they like to do, and it's called skitching. And in some cases, drivers will try to get them to stop doing that because short of stopping the car and telling them to stop doing it, you cannot do it. It's illegal, of course, I'm sure, in most states, if not all states, and so is hitching the ride. But I just added that as a possible explanation, as if you know that there's somebody there, you still have a duty not to create more danger for them. And I don't think it's legal for you to speed up and go over an obstacle for whatever reason. And you're criminally immune from prosecution because they did something illegal. And that was my point. But again, we'd ask the court to affirm.
Any further questions? All right, thank you.
Thank you.
Now, the state makes a lot of arguments, Your Honors, that were not contained in their traverse. There was a passenger in the passenger seat alongside where the decedent was holding on to, and they used none of his testimony to put into their traverse. And now, I have to accept the fact that the state's expert estimates the car to be going between 29 and 42 miles per hour, because that's what the C4 at the traverse alleges, and the trial counsel had to agree with that. If that were true, if there was something that person, the passenger, could have added, I assure you the state at the trial level would have asserted that in the traverse, that vehicle was speeding, that the victim was frightened or scared or didn't want to continue in that direction or at that speed. That is not contained in there. They had adequate time to put that in their traverse. They did not. The only thing contained in there is the estimate of an expert who estimated to be going that fast. I mean, if we're going to sit here and engage in conjecture, I don't know how you get a shopping cart with tiny wheels to go 42 miles per hour at any speed. I mean, that's almost unbelievable. But having said that, we have to accept that, because that's what trial counsel did at the C4 motion. And he admitted to the court, and it is reckless driving. There are lots of examples of reckless driving. The real question here, and there's a lot of discussion with regard to what Velasquez states, and I had to read it 6 or 7 times myself to really understand it, but they get to what is, rather than the proximate cause, there's other name for it is legal cause. And, or stated differently, it is a responsibility question. Should we hold one party responsible in a mutually agreed upon activity? You know, was this foreseeable when you pull a shopping cart up to, the decedent got out, and apparently was his idea to get the shopping cart, attach it to the thing, and proceed forward? Is that foreseeable that something like this could happen? Well, I submit to Your Honors, yes, that is something that is foreseeable. And when two people mutually engage in this activity, death is unfortunately a likely outcome. And with that, Your Honors, I submit that this should be reversed and sent back to the trial court with an order to grant the motion dismissed. If there are any questions.
All right, thank you.
Thank you.